The arrest of former State Bank of India Chairman Pratip Chaudhuri from his residence in Delhi has sent shockwaves through the banking industry. Now, Mr. Chaudhuri, on the face of it, has been arrested in a matter where a borrower and his loans went bad. It was a hotel property, and that loan became an NPA while he was in the State Bank of India. In fact, a few months after he retired, that specific asset was given to an asset reconstruction company, and then that matter was closed. Now the original borrower has gone and filed a complaint, and based on that, Mr. Chaudhuri has been arrested. A lower court has refused to grant him bail as well. Now, at the outset of this, I want to make it clear that we're not passing judgment on the merits of the case. It's still undergoing a legal process, so we'll have to wait and see what the real reasons were, and we can't judge innocence or guilt in advance. What we are trying to do here is look at the red flags this case raises at a time when so many different kinds of companies are going through the insolvency process. The insolvency process is one of the big reforms that India has undertaken, and it has helped bankrupt companies and many banks actually find closure as far as their NPA problem is concerned. So to give us perspective on what is quite a crucial story, I'm joined today by Mythili Bhusnurmath and Tamal Bandyopadhyay, both very senior journalists who have tracked this space closely for decades. Welcome to both of you, and thank you so much for speaking with us. Mythili, let me begin by just getting your take on what we have seen with this Pratip Chaudhuri affair and what we know of it so far. Of course, State Bank of India has come out with its own statement, but many in the industry have raised concerns, haven't they?
Well, absolutely. In fact, there are two very major issues with this. One is the presumption of guilt and of malified intent. Because remember, the government has been trying very hard to assure bankers, particularly public sector bankers, that they would not be proceeded against, no investigation would be launched for decisions, bona fide decisions that are taken, and would subsequently go awry. So here is a case where there's a presumption of guilt, there's a presumption of malified intent, and here the chairman has been arrested, former chairman has been arrested. Secondly, there is the issue of denial of bail. The normal rule in jurisprudence, at least, should be bail, not jail. Whereas here you have a former chairman being arrested, number one, without any proof that there was some malified intent. Due process seems to have been gone through, as the State Bank itself has vouched. And then you have the issue of denial of bail. So the whole thing, is completely at cross purposes with the government's intention of assuring bankers, please lend, please go out and lend. Remember, one of the criticisms against public sector bankers is that they do not proceed to write off, to come to a decision quickly. Cases linger for years on end, whereas private sector banks are much quicker on the ball. The reason we now know, because public sector bankers know that even after retirement, they can be persecuted, can be proceeded against. And this goes completely against government's intentions. No public sector banker is going to be willing to lend even a shilling or a rupiah or a paisa, whatever you want to say, if this is the fate that awaits them. Very unfortunate day for Indian banking, Tamal.
So here we don't know exactly what has happened, because Mr. Chaudhuri also became involved with the ARC at a later stage post-retirement from his position from State Bank of India chairman. And Mythili very correctly points out to the, bail being the rule, not jail. We've seen that debate come up recently in another high-profile case as well. But Tamal, in this particular case, again, we don't know what essentially will be found, whether there will be an investigation. At the face of it, the question mark years later over why you took a decision while in your position at the helm of a bank, that is what worries us. And we already know that there's a protection against it. That check and balance was put into place, wasn't it?
Yeah, Mythili spoke about the fear psychosis bit. I think much of it what she had said actually is applicable to the officials in power, in the sense the existing chairman and all. So I'm not very sure whether the past chairman, past bosses also covered by these, like that they won't be touched without being told in advance, being the government being consulted or the concerned bank being consulted. I don't know. But what I know is certain facts, and I place before you without making any judgment. The company or its properties were never sold by SBI. The bank never sold it. So valuation which the order mentioned, I don't see any relevance because banks never sold it. Now, what's the background? This SBI lent 24 crore term loan, and a CC limit, credit limit was 1 crore sanctioned by SBI in January 2008. Now, loan was restructured in January 2009. A year later, no loan became NPA in July or June 2010, another year later. Recall notice of 33.93 crore was issued again in January 2012, and a suit filed with DRT in 2013. What was the money was asking for? Close to 40 crore, 39.769 crore. Surface notice was issued, but the chief judicial magistrate, I think, did not act on it, or it took time, etc., etc. So at that point of time, bank assigned the loan to ARC, Alchemist in this case, for a consideration of rupees 25 crore. Essentially, the objective was to recover the entire principal. Incidentally, probably a year back, it was done in March 2004, 6 months before. In September 2003, Pratip Chaudhuri retired. Then what happened? ARC moved, it took forward to the DRT case, tried surface action, and borrower was litigating. I think that is his right to be litigated. I mean, for going for litigation, it was done. Now, finally, what happened? ARC invoked IBC because time was running out, and by the time IBC is in place. So the application was admitted on 31st March 2017. IBC was in place after a long period of litigation happened in NCLT, then the appellate authority, and even Supreme Court. Finally gone to IBC. Then the promoter files an FIR against the RP, that is the resolution professional, resolution who was handling it. Now RP was arrested and to seek protection from the court.
Yeah.
The court in this case, if you remember, and gave a landmark order, a criminal complaint can only file be IBBI. That's the IBC authority, not against RP. Nobody can do that. So both NCLT and Supreme Court have passed stricture against the promoter in their orders. You can't do this. Then the RP invited resolution plans in public announcement. Again, it was not done bilaterally. Public announcement. COC, the Committee of Creditor, found the plan submitted by JFC Finance, who is the buyer in that case, most suitable. So it's not SBI has not done it. It's the Committee of Creditors found it suitable.
Yeah.
NCLT approved the plan. Promoters tried to delay it, but did not become successful. So the entire process and the numbers and the dates I am telling you, it's correct. It's pretty transparent. The bank sold its financial assets, which has no relation with the value of the security, and it was done through public notice. It was done through the proper resolution professional.
Yeah.
But then nothing was discussed in the order. So this passing of the order against the ex-chairman of State Bank of India and arresting him against this background, I would find it a bit difficult to stop.
Yeah, so, the question also is, and the reason why we're finding this very important to talk about, because there are several examples of promoters kicking and screaming to hold on to their companies till the very last minute. You see that time and again, in case and again. So, Mythili, is that the concern, that this sets a precedent? It sets a pretty bad precedent. And several years down the line, this ghost of a decision taken long back could come and haunt any banking official, and that may have a chilling effect.
Oh, well, absolutely. In fact, the Parliamentary Standing Committee, which went into the issue of the IBC, came on very heavily, saying that the IBC really hasn't served its purpose, simply because our judicial procedures are so long, let alone the promoters being unscrupulous. Yes, many cases, you cannot expect anything very much better, perhaps, from many of our promoters. But the fact is that why does the judicial process itself take so long? That itself is part of the problem with the IBC. We should have a quick, speedy resolution. And if this is not going to happen, then you are going to see cases like this where somebody retires and years later something is raked up and he's put behind bars without even being a proper show cause notice being issued. So I think this is something that the government really does need to do something about. And we've seen the Prevention of Corruption Act was amended in 2018, and ironically, the government had just come out with a uniform policy guidelines saying in the case of middle-level bankers, loans that go bad up to about 50 crores, you must be very clear that you do not penalize them for bona fide decisions go wrong. And here is a case where prima facie, all the due process was gone through. And because the promoter wants to kind of has his own axe to grind, and the police take the law into their own hands, as it were. So, as I said, it's going to set a very wrong example. First of all, it's unfair at the individual level. And secondly, at the systemic level, because you're going to find banks becoming increasingly unwilling to lend. We're already seeing that banks giving more and more of retail loans, nobody wanting to lend to the corporates. So ultimately, we're shooting ourselves in the foot.
Yeah, absolutely. Tamal, just a roundup from you on what you would expect to see next. The legal process will continue as it does. But right now, perhaps the former chairman of State Bank of India is finding himself just left alone, right? Because the bank, as is not a party to the case at all.
Absolutely.
Nor is his former employer, who was essentially the government of India. So he is left carrying the can for those decisions. So what would you hope to see in a case like this?
Yeah, no, other part is this, I think, because he is an ex-official, I'm not very sure whether he gets the legal expenses borne by the bank. I'm not very sure. I think it depends on what's the bank's rule. I'm not very sure on that. So apart from all the harassment, there's a financial implication also. But I think it's a one-off case, because the so-called rigging and the IBC process, etc. What we have seen till now, it's basically promoters' way or the connected parties' way of bringing down the price and forcing the banks to have a massive haircut. That's what happened. That provoked even Harsh Goenka, an industrialist, to tweet that what's happening in IBC. So that's one side of the story. Here is completely. I don't know how to classify it, because this gentleman has nothing to do with this. It had happened with transparency and following the due process after his retirement. So I really don't know how to classify it, but it is indeed what Mythili said. It's not good for the industry. It's not good. It's a big discouragement for people taking decisions while in office, and it's a setback for the loan restructuring process and recovery process.
Absolutely. We'll be tracking this case very closely right here on ET Now, with all of the updates coming through. Once again, we're not prejudging innocence or guilt or the outcome, since it is now a legal process, but it does raise questions over concerns that bankers currently may have when taking these important decisions with large financial implications. Thank you so much, Tamal and Mythili, for joining us on the discussion today.
Thank you. Happy Diwali.
Thank you.